the right time to use a copyright?
Great. Copyright law. So that copyright law is found in Title 17 of the United States Code, and it protects original works of authorship that are fixed in a tangible medium of expression. So this means that we first must have a work of authorship, and that work must be original and it must be fixed. So independent creation means that the work must be independently created by the author. And what we mean by that is that the work must originate from the author and not be copied from another work. So in theory, two works could be the same or similar and each be subject to copyright protection, so long as the similarities are simply by chance rather than a result of copying. Sufficient creativity requires that the work contain at least a small amount of creative expression, but the small amount must be more than trivial. So examples of works that do not meet the requirements for originality here could include words and short phrases, something like names, titles, and slogans. So if you're trying to think of a name or title for your invention, that would not be copyrightable. Other examples include familiar symbols and designs and simple geometric shapes. Typographic ornamentation and typeface or lettering are also not protected. And then mere variations of coloring are not protected.
And what about a logo? Because a logo can also be a trademark, but can it also be a copyright?
Great question. So I would say that the logo can be covered by copyright if it has sufficiently creative artwork. And especially if you're talking about a logo with a name, a business name, for example, or a slogan, that portion of the work is not going to be protected by copyright. But if there's sufficiently creative artwork accompanying that logo, that can be protected.
We've had the U.S. Trademark Office. So the TM is a trademark.
Yep.
And that puts people on notice not to use your name or your logo and or name in a certain class of goods. When you register it and you show that you're using it in commerce, it converts the TM into an R, a registration mark. I'm not going to get into service marks, but that's that. And then sometimes you see the C with the circle around it, and that's the copyright.
Correct. Yes. About who is a copyright owner. So initially, an author of a work is the owner. And in most cases, the author is the person who created the work. So they are the initial owner. But in certain situations, the author may not be the person who actually created the work. And this comes into play most popularly with what's known as works made for hire. So this is, I think, a well-known phrase, but what it means in copyright law is very kind of specific. And I'll try to explain that here and break it down. It's also broken down on the slide. But essentially, there are two parts of the definition of a work made for hire. It's either created by an employee in the scope of their employment, or it's a commissioned work that fits into one of several specific categories listed in the law, and the parties in that agreement have entered into a signed written agreement explicitly stating that the work is a work made for hire.
All right, Joe Vanek, is all of this protection benefit only pertaining to the USA? What if there is a foreign entity that infringes?
Sure. So I will just answer this by saying there is no international copyright. When we talk about copyright and what the office provides, it's registration in the United States. And so there are registration systems that exist in different countries internationally. The best resource for this, again, is on our website. There is information in an entire webpage, resources dedicated to international questions such as that. But I'll just keep it simple at that there is no international copyright, and we're talking about works here registered here in the United States. We are continually developing our technology as well. So the enterprise copyright system is something to be kind of on the watch for, ECS. That'll include the office's registration, recordation, public record, and licensing IT applications, among many other functions. And then one last thing in terms of copyright for all, I just wanted to put this on everyone's radar. It's what we're calling the CCB. So the CCB is the Copyright Claims Board, and it came about as a result of legislation in December 2020. But as of June 16th this year, we created the CCB. It's been in full operation. Essentially what it is a small voluntary small claims tribunal within the Copyright Office that hears certain disputes involving claims up to $30,000 in damages. So it's a voluntary alternative forum to federal court, which many of you know is very expensive and timely and takes a lot of time. So that's something that I just wanted to put on everyone's radar. And in terms of that website, it is ccb.gov. So our website is copyright.gov, but ccb.gov is out there as a form for you to use if you are experiencing copyright infringement or other issues related to copyright.